Plains Angels was started in 2012 and is an initiative of the Greater Des Moines Partnership. The Plains Angels are a group of Midwest angel investors dedicated to providing outstanding financial returns while assisting early-stage growth companies by being an excellent source of funding and advice. Find out more about Plains Angels by visiting www.plainsangels.com.
And I actually absolutely accidentally stumbled into law. My sister was a lawyer, and she said, "Oh, you should go to law school. You want to get a well, it's one more thing to do." Okay, another certificate, good deal. I got out of law school and interviewed for jobs in the corporate law area. And as I was interviewing, I ran across somebody who was a patent lawyer, and he said to me, "Would you consider working in the intellectual property area?" And I said, "What's that?" Because I had no idea. And that is an absolutely true story. So he said, "Start here. If you don't like it, we'll move you back over to corporate." So I started there, and I fell in love with this area of law because I don't love the technical, is it legally correct stuff as much as I like the technology involved in patent law. But I have to know the law in order to apply it, in order to do my job. So it works out pretty well. I get to do things I really like. I also get to use something that I paid for education-wise. And I like the whole idea of verbalizing all of that for others to understand. So this is right down my alley, and I love doing this presentation. This one's a fairly basic presentation, so I probably should first do a little bit of a kind of a survey of the room, because I can kind of tweak it as we go and see how much intellectual property knowledge there already is here and whether there is none. First of all, how many of you have a company that has a trademark? Registered trademark? Okay. How many of you are working with a company that owns patents? 3 or 4? Okay. About copyrights? 3 or 4. I would wager that if any of you are working with any company at all, that when I ask you about copyrights, here I should have been on. I would wager if there's anybody here working with a company at all and the company has a name, and I ask about trademarks, your arm should have gone up. So it wasn't a pass-fail test. I just wanted to get kind of an idea of where people are in the room, and that helps me a lot so I can tailor this going forward. Okay, so what is intellectual property? We'll start there, and then we'll work through the several different types. Intellectual property is intangible. You can't touch it, see it, feel it until you put it on a certificate, hand it to you, and say, "Ooh, registration." It is protectable, and that's what we're going to spend some time discussing today. And most of the time, you protect it because it has value to you, and most of the time that value is related to your competitive advantage. It can be anything, but these are your typical things. So try to give you kind of a broad line and a broad list so that you can think through what you might have that might actually be intellectual property. Notice customer lists? That's intellectual property. Not just trademarks, not just patents, not just copyrights. There's computer programs, the software. All the coding is protectable as either a trade secret, also copyright, perhaps patents. So one piece of intellectual property might be able to be protected as all 3 or 4 different kinds of intellectual property. Business plans, market intelligence. You probably aren't going to register that as a patent. You're probably not going to register it anywhere if you really don't want anybody else to know it. But that's a trade secret, and it is also protectable. Now, if you have X number of dollars and you're putting that many dollars into your company, the last thing you want to do is lose that money. The first thing you want to do is increase that value. And so that's one of the reasons that we talk about intellectual property. It is an unknown, typically unvalued kind of revenue and also value. The problem is it doesn't show up very well on balance sheets. And that, I can't change that. But when you learn to talk about it and understand what that value is, when you're talking to potential investors, that will give you another aspect to discuss with them. So translation of reaping the full benefits of innovation is money, value, and competitive edge. How do we get there? Well, the first thing you have to do is we want to create value, we want to create revenue streams if we can, and we want to maintain or create a better competitive edge. The first thing you have to do is you have to determine what kind of intellectual property you own. So my first question of the day, do you own a trademark? Probably you do. If you are calling a service something, have a name that you use when you talk to customers about it, that's a trademark or a service mark. If you are keeping anything competitively secret from anybody else, because if you let that out, you believe that they would then know your secret and be able to compete better with you, then you have trade secrets. If you're not keeping those secrets well, then your trade secret will be a very temporary trade secret, because the minute it becomes public, it's no longer your secret. We're going to not only determine what intellectual property you own, we're also going to talk about different ways you can protect it. That's our main topic today. Some of you have been around intellectual property enough that I'm not going to spend all of our time on that, although most of my slides are on it. We will, at the end, we'll talk about some different applications of what it means to have that intellectual property and how you can best use it. You also need to evaluate whether it's worth protecting. Some of those service marks you might have, maybe it's a service that you offer now, but you don't really consider it to be a lasting offering. You might not want to spend the money to register that. Or you might not want to spend the money to register a trademark federally, because really your market's more within a state or maybe around your own metro area. If that's the case, a state trademark is probably enough. Or if you think it's temporary enough, no registration is probably necessary. So there are different degrees of all of these things. And I'm going to try to help you kind of get an idea of what those degrees are and how to evaluate it. And then the fourth prong is really for another day. But the whole idea behind this is identify your intellectual property and then figure out what you can do with it. So hopefully we'll get there someday. Here's the key. Start early. Think strategically. It's already late. Start now. So don't wait on intellectual property. It'll get away from you. And the rights to intellectual property can be lost fairly easy without you even knowing they're gone. Our four types of intellectual property, which I ran through just early in the discussion, is patent, trade secret, copyright, and trademark. Now, a patent is a grant by the government. It is an actual piece of paper. It feels like a property deed, because it kind of is a property right. And this is your right to exclude others from your invention. It usually covers a patent, a process, a method, a thing. It doesn't cover an idea all by itself. It has to cover something that would be process-oriented or thing-oriented. It lasts 20 years from the date that you file it. And again, it's the right to exclude others. And you're saying, why does she keep saying exclude others? It is not your right to practice your invention, which sounds really backwards. And it sounds completely illogical. But all it gives you the right to do is to keep somebody else from doing your invention. Whether or not you actually have the right to practice your invention depends on the other patent rights in the world that somebody else might own. And we'll talk about that a little bit more in detail. A trade secret I alluded to earlier is really anything that you keep secret that could be advantageous to your competitor if they knew it. Keeping it confidential does not necessarily mean that you have to have Fort Knox, but you have to have a way to protect it that's reasonable in the circumstances. Think about that, and that's not any kind of standard whatsoever, whatever reasonable in the circumstances might mean. Basically, though, if it's something that is in your computer, you can protect it with a password, and you should. If it's something that lays on someone's desk, then probably, and you have to have it out to do the work that you're doing, then you probably need a sign-in log at the door, and you need to make sure that no visitors go beyond this point. I know these sound very simple, but these are the kinds of exercises that we go through when we're working with our clients and how do you protect your trade secret. And often we find that they're lucky that their trade secret is still their trade secret, because there are lots of people in and out of various offices. Computers are password protected, but they might not have a sleep mode that turns them off that requires a password to get back in. There are a number of different things that can be done to improve the secrecy of your trade secret. And a copyright. A copyright is your right to keep others from copying a creative work that's fixed in a tangible medium. And here's the mouthful, can be separated into smaller parts. So tangible medium can be on paper, in a computer, on a computer disk. It can be sculpture, it can be film, it can be sound, it can be anything that you can store on something or store in some way. That, as long as it has some some amount of creativity in it, it is copyright protectable. That could be a business plan. It doesn't have to just be something really pretty that somebody put on a piece of paper and did a painting of. And I think most of us, that's our original thought. And then we've had a number of copyright cases in the last 10 years that have to do with music and software. And now we're all getting so that we're a little bit more aware of what copyright can protect. Copyright attaches the minute you fix that idea in a tangible medium. So when your child does the cutest drawing in the world and you put it on the refrigerator, there's copyright in that. Whether you register the copyright or not, again, kind of like a trademark, there's a question that you can answer, and the answer is typically driven by value of that thing in your business. And then there's a trademark, and a trademark is an identifier of a service or a good that is used in commerce. If all you're doing is calling something a name internally, and you're not using that name in a way that's actually selling it, that's not a trademark, that's just the name of the gizmo. If in fact you are discussing in public or in private, even if it's private confidential conversation, if you're discussing something that you're offering for sale or license in that situation and you're using a name or an identifier, that's a trademark. And trademark rights start the minute you start using it as a trademark, whether you register it or not. So the next question should be, well, if it's already have rights in it, then why would I bother to spend the money to register it? Two reasons. One is a federal trademark registration is good all over the nation, and that means it works as notice to everyone in the nation that you have this trademark, whether they saw your notice or not. So if you find an infringer, and at some point you need to go after that infringer, they can't say, oh, I didn't know, I never saw. They have no rights to even have that defense at all. So that $900 or $600, whatever you spend going when you make a registration, is a well invested money. It also establishes for the court who owns it, when you started using it, and what it's used for. And sometimes the court will just say, look, if that was proved up at the trademark application stage, that's good enough for me. And we don't have to go any further with that. So it can save you easily, and that's 2 hours of lawyer time right there. That's all it takes. So it's probably worth it. Okay. Patents, I kind of covered this already, but I wanted to make sure you have slides so that if you didn't remember it, didn't write it down, you don't have to now. But again, that right to exclude is really important. I'm going to give you an illustration that I use every time I'm standing in front of a crowd, and it works well, so I keep using it. And if I think of a better one, I'll start using that one instead. If I have a patent on a pen, we all have pens, right? So I have a patent on a pen, and it is the patent to the ink cartridge and to the cylinder on the outside. And that's what it covers. Pen, writing utensil having an ink cartridge and an outside cover. That's my patent. Now you come along and you say, I like this pen a lot. I cannot keep it anywhere. It rolls all over the place. It drives me crazy. I want a way to stick it in my pocket so I can't lose it. So you come along and you have an ink cartridge with a cylinder and a clip. So now you can stick it in your pocket. So my patent is just the ink cartridge and the cylinder. You can come along and ask USPTO for a patent on an ink cartridge, a cylinder, and the clip. And the USPTO will say, ooh, that's new. You can have a patent on that. I have a patent on the ink cylinder or the ink cartridge and the cylinder. How are you going to have a patent on the ink, the cylinder, and the clip? Well, you can. It's an improvement patent. But in order for you to make your pen, you have to infringe my patent. Because mine only requires 2 things. So this is why you have the right to exclude, but not necessarily the right to practice. Excuse me. So the pen holder, the pocket, the pocket gauge, actually does not give you a right to practice. It just gives you a right to patent. Is that like clear as mud?
Yeah.
Okay. Let me try this again. I'm trying to think of, this is an example that usually works. So, in order to infringe a patent, let me start back there. If I'm going to infringe your patent, it's because I have done every single limitation in one of the claims in your patent. And so if your patent is to just the ink cartridge and to the cylinder, and I have an ink cartridge and a cylinder and 10 other things, I'm still infringing your patent right. Now, does that make more sense?
Mm-hmm.
Okay. So you own the ink cartridge and the cylinder, and I come along and now I've got this thing that hooks it into my pocket. I'd really like to sell this thing that hooks it into the pocket along with the pin, and I can't unless you tell me I can by giving me a license. Is that better? Yay, 2 points. Okay. We can come back to that and discuss that in any level of depth that you want to. There are some problems with patents. One is, sometimes we don't think we really want a patent until it's too late. So anytime that you're going to go out and disclose something to the public or disclose something to your neighbor without a non-disclosure agreement, you need to think long and carefully before you do that. Even if you don't think you're going to want to seek patent protection, it's still a good idea to go through some sort of an exercise within your organization to determine whether in fact you might want to. Once you have disclosed your invention, there are some countries, in fact most of Europe, that says, you disclosed it, you're done. No patent protection for you. In the United States, historically, we always had a 1-year grace period. A couple years ago, most of you might remember, we changed the patent law, and it was, this pretty big, huge change. And there's been some changes. I had to get used to some of them. But it's not totally clear whether we got rid of the 1-year grace period or not. And to me, I thought that's exactly what they were going for, because we wanted to be unified with the rest of the world. And yet there are plenty of patent scholars who are saying, no, we haven't really gotten rid of the 1-year grace period. So what do I tell my clients? I tell my clients it might be gone, let's not take a risk. So if you are ready to go to market, or if you are ready to discuss your invention with someone else looking for funding or any other purposes, then I try to tell them to do one of two things. Either put all kinds of agreements in place that allow us to pretty carefully and pretty confidently say that it's probably protected, or get at least a provisional patent application on file. So in the U.S., we have 2 possible ways of going after a patent. The first one is you can file a provisional patent application, and it sits there. Nobody in the U.S. Patent Office looks at it, nobody does anything with it. It simply gives you 1 year from that filing to decide what you really want to do. And during that year, if you decide you really want a patent, then we put a utility patent application on file. If you decide you don't want to, we just let that thing ride and it dies and nobody ever sees it. Okay?
Are you protected by any infringement during that grace period, during that 1-year period?
You're not protected from any infringement during that grace period. What it does do, though, is it secures your date. So the way the Patent Office works is this. When I send in an application, the first thing it does is it looks to see if there's somebody else's patent out there or patent pending application that looks too similar to the one you just sent me. And if I don't think that there is, then all is well. And if I do think that there is, then we go through the whole examination process. But the patent examiner can't look for anything that was filed after yours to preclude your rights. It has to look before this filing date. So the provisional application in the U.S. gives you this filing date, even though you have the right to go in, I don't care anymore, within a year. But if you decide you do care, even though you didn't spend your 10 grand or whatever it would cost you to get your real patent on file, you have secured this date for $1,500. It's a pretty inexpensive way to secure a date while you're trying to figure out exactly what you want to do. And so that is the beauty of the provisional application.
And what would you, let's say that we've got a provisional, and how much lead time is it to get the utility typically? And do you need that full year of lead time, or as long as it's right before that date?
You know, that's a good question, and it's going to depend on at least two things. It depends on how busy your patent attorney is, and it depends on how far down the road you were when you filed the provisional to begin with. Some people put 2 or 3 different provisional applications on file before they ever get to the point where they're ready. And others put a provisional on file when they're almost darn near there, but the idea is that they're close and they're worried about it getting out, and they want to make sure they can secure that date. and then they hurry up real quick, and maybe 2 months later, they're filing an actual utility. So it really depends on your needs, depends on your commercial development level, and it depends on how busy the people are who are going to put that application together for you. That was kind of a wishy-washy answer. Sorry. So if you want to file a patent, if I were you, I'd file it before you do public disclosure.
So what actually constitutes public disclosure? Is
Well, I
that
knew someone would ask me that question.
you have a little seminar and you show your friends and family how this works? Is that disclosure, or is it
It is.
having a newspaper article done about you?
The truth of the matter is, if you disclose it to your friends and family, it is a public disclosure. The question is, will anybody ever find out about it? So the practical answer is, it's probably not a public disclosure, because probably no one would know that you showed your friends and your family. If, on the other hand, you are meeting with a developer, because you really need a developer to finish this thing, and you meet with the developer and you disclose to this developer all the things that you do know, and you say, and all I need you to do is finish this over here, and you have nothing in place with this developer, that's a public disclosure.
Okay.
Trade shows or those kinds of things you can see easily, but some of these other weird little things in between. So you say, well, so what? Well, here's the so what. So you've got the greatest patent on earth. Everybody wants to do what you're doing, and they can't, because you have the right to exclude based on your patent. And somebody says, really big, there's got to be a way. And they start digging into what you were doing about the time you probably knew this and had developed your invention. And they start looking, were you at trade shows? Who did you meet with? Oh, it would have been someone who would have been right. That would have been a customer right in line with exactly what this invention was that you came out with later. I wonder if they discussed that. So they start, it's detective work.
So what kind of document are you having in place with the developer, though? Is that just simply a confidentiality, non-disclosure type of agreement?
It is a non-disclosure confidentiality agreement.
Okay.
And there would be some people who would say, I don't know if that's going to work all the time. Well, it's way better than not using one.
Okay. Thank you.
Yep. Here's the other weird thing about patents, and that is, if I'm the inventor, then it's my invention. Well, that doesn't sound too out of whack. But if you're my employee and you make an invention, then do you, my employee, own it, or do I, the employer, own it? And the answer to that one is twofold. One, I, the employer, am going to own it, probably if it's in line with exactly what you were hired to do, i.e. I hired you as R&D for a particular kind of furniture, and you came up with the neatest piece of furniture like that ever. It's covered probably, or could be covered by a patent. Then the employer probably owns that. That's pretty narrow. What happens when the guy in shipping has been wandering down the line at the factory and goes, that would work so much better, because he's one of those guys. And there's always one of those guys in every company. So he's one of those guys. He says, that would work so much better if we did this, this, and this. And, oh, that's great. I'm so glad. And he goes and sees the patent attorney, and the patent attorney says, your employer doesn't own that. You do. You're the guy in shipping. This is not in your area of employment. This is not what you were hired to do. Even though you got your idea there. You went home and you worked on it in your garage. They have no ownership claim to that. Did that surprise anybody? Most of the time I have several people who go, what? But that's really true. So they're by default, they're owned by their inventors. What if you and I decide that we're going to create, I don't know, something new, like a new holder for my phone because I can never find it, and I need a little beeper that will find it wherever it is. I don't know, that's not a good idea. But let's pretend that's what we're doing. So we sit down and we have a glass of wine, and we figure out exactly how to do that, the two of us. And you have an uncle who is in manufacturing. And so the uncle says, oh, sure, I'll make it for you. And then you say at the same time, well, before we do that, let's get a patent on file. So you do, the two of you, and you file a patent, and it's in both of your names because you were both inventors. And then you get mad at each other. It's sort of like a bad marriage. So now you got to figure out how to get divorced. And your patent is like your child, and you cannot split your patent. So you were co-inventors. You both own that patent, and you both have the right to do with that patent the same as the other person does. So now you're both out there in the marketplace, and you say, fine, we'll just compete with each other, because we don't like each other anyway. So now you compete and you drive your prices right into the tank. Bad situation. Better situation is, we've got co-inventors involved. What do? We decide upfront. We're either both going to own the patents, and one person's going to pay royalty to the other person for everything he or she sells. Or you might decide that one person's going to actually end up with the patent, so you file it both your names and assign to one person for a price. There's a lot of things you can do, but the default is ugly. It's always ugly. So if you see a co-inventorship situation arising, run or fix it. Okay. Employee invention agreements, as we were mentioning a minute ago, typically this is what happens. An employee starts working for an employer and they get the handbook and they sign all the pieces of paper. And one of those things that they sign is anything that I invent, either on company time or with company equipment or within my job responsibilities, you own. And that is the easiest, fastest, simplest way to avoid the problems that I was mentioning earlier. But you can't say anything you ever thought of while you're my employee from day one to 10 years from now, I, the employer, own. You can't reach into what they're doing elsewhere. Two questions.
If the employee says, I didn't use any company time or equipment, but I went home and I invented this, can you create agreements that cover that as well?
If it's within his scope of employment, what you would expect him to do, yeah. Yep.
So I oftentimes will have an entrepreneur come to me and say, I get this idea when I work for this company, but I'm going to go start my own company. And it's not directly what this company does, but it's in the same field. Mm-hmm. And so as an investor, I say, you really want to go to that company and get something from them saying they relieve you of any responsibility to them. That makes them very, very, very nervous because they're afraid the company will take their invention. Yet I'm very worried as an investor or representing other investors to say, well, you built this thing and you worked for this company. They may lay claim to it. And if they've got enough money, their principal financial or Wellmark or somebody big enough, they've got the means. So how do you advise people?
I have two answers to that. And one is that, A, you need to look at whatever agreement they did have with that employee. So, because sometimes there's enough of a four corners that you can make that analysis and be comfortable with it. The other thing, though, is that especially in Iowa, and there are other states in the union like that, but not everywhere, we have pretty good employment laws. And so our employment laws would basically say, you can't unreasonably reach outside the scope of someone's employment and take property or keep them from working for a competitor or a competitive interest. So, you've kind of you've set up a situation that is kind of quasi non-compete and quasi inventorship question, and those are the real ones.
It's just not obvious to you on either side. It's the concern of the investor I'm worried about, saying, you invented this while you're working for this other company, and it's in the same general field. I'm not, I get you on the law, but I mean, does this cause a problem down the road if that big company comes back and says, whoa, 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 stop the IPO?
Yeah.
We think we might own a piece of that now.
Yeah. I think that's a reasonable concern, and I would address it two ways. One is I'd ask that person for their employment agreement.
Okay. What if they don't have one?
And if they never had one, then I would ask them for a very good description of what they did for that company. And then I would ask, now, where did you develop this company? Because really, if it's on company time or with company stuff,
Right.
That's a big problem.
See, I guess I'm not trying to make it harder on you. I guess
That's
what,
right.
if it's gray, if there's no way to know for sure, do you go to that company and say, I want a release?
You certainly can, and you could be raising red flags all over the place. And it depends on how far away it is from their normal business interests. It really does. Time also creates a difference there.
Yeah.
So, even though they might have come up with this idea while they were employed, if it's 2 years before they ever get out there looking for investments, that's a different question.
It's notoriously when they're still working for them.
Oh, I know. It is. You're right. Okay. And then I talked about the co-inventors, so I'm not going to go back through that again. So that's about it for the patent pitfalls.
Camille, just a corollary to
Yeah.
Mike's question. I mean, in reality, the rights you have under a patent are limited to your ability to defend that patent.
They are.
Because there are, a lot of times a small company will get a patent, and there will be gray areas in the IP that's claimed, and a big company will come in and just do it. They'll infringe with impunity and say, sue me if you don't like it. So how do you deal with that? Or how do you advise clients with that?
I don't think there's any good answer for that. I mean, I think, without a question, large companies can do that. They don't like to really be in a position that it would be an easy prove up for willful infringement. So depending on the small company, you have a couple of different options. You could turn those sour grapes into wine, or whatever you want to say. And you could say, look, you're using it, and I don't care. But you own me. I developed it. Those are my rights. And I'm willing to be reasonable. And by doing so, I'll get a revenue stream into my company that I would not have otherwise had. And perhaps there are 2 different ways, or 3 different ways, or 4 different markets to use these patent rights in. You might be able to negotiate a, look, big guy, this is your market over here. It's always been your market. If you promise to stay in that, pay me this royalty. No problem. I mean, I would try to negotiate my way into A, a revenue stream, and B, keeping a market that I would like to live with, and C, I'd be developing all over the place trying to get away from that patent. Those, I know that's not probably the perfect answer you're...
Well, I mean, but still, you still have to force that, and that's going to cost you money. And if you're going up against Apple, like Samsung did with their Galaxy phone, they have huge resources. But if a smaller inventor had something that was then kind of snatched from them, it does become a real problem.
Well, and that is one of the reasons why I was suggesting negotiations rather than a legal sort of lawsuit at all. I would try negotiation first. The bigger companies that are fairly reputable, they for the most part are usually willing to work with you. They don't mess around with another lawsuit either. It doesn't help them at all. You might not get the better end of the deal that you would if you had better leverage. But still, if you could get them in a license agreement, the license agreement has terms. So it's going to have a time term, a place term, it might have a royalty requirement. You can do agreements with milestones, so when they sell 2 million of them, now all of a sudden your royalty goes up. There are ways to do this, to make it not hurt so badly, but it's going to hurt.
It's actually gotten easier to be the small guy with social media.
Yes.
We've seen some situations where larger companies were ignoring, and it got out on social media and started hurting their brand. So it's kind of a sad way to do it, and I wouldn't see that starting that way, but I've seen a few people resort to saying, why is this big company stealing my idea, and got a little tension and it got settled,
Yeah.
to your point.
I think that's right. And
Put some
also,
pressure in.
there are some relatively tasteful ways for that kind of information to get out also. And then you're going to gain a little bit more momentum.
Exactly.
With it.
Well, and they have competitors too that, could certainly, might be interested in buying your IP if they, if that's something that who have the balance sheet to fight on it.
That is very true. And that could be a very real threat, which is, I can't sue you, but that guy can, and I'm going to sell it to him. We mentioned trade secrets momentarily. They are the simplest way to keep intellectual property, but it's also sort of a fleeting way. It only takes one person to go out and decide they're going to tell the trade secret that you thought you had well protected. And once it's out of the bag, you can't unring the bell and can't put it back in. So that is the problem with trade secrets. It also requires a protection program. You can't just say, just don't tell anybody. You're going to need agreements. You're going to need, as I mentioned before, some routine within your business that helps you to be able to show the court that you have in fact made reasonable efforts to protect that information. Great thing is, it doesn't have a 20-year limit. You can keep a trade secret forever. As long as it has value, would have value to your competitors if they knew it, you can keep it forever. Here's the tips, and I think these are good ones. Don't tell anybody your trade secret unless they need to know it. So if it's a pizza sauce recipe and there's only one guy in the kitchen that has to make the pizza sauce, nobody else needs to know the pizza sauce recipe. I mean, it's funny how employers think that they're doing everyone a great favor by kind of bringing them into the fold and teaching and telling them a lot of confidential information. It does make people feel great, and probably it might be a good employee retaining sort of approach, but it's never good to have more people know your secret than necessary. Educate your employees and obligate them. Let them know the reason we have passwords on our computers is this. The reason we have logins at the front door is why. The reason we ask you to shut your door to your office when you're not in it is because. The more that they understand the reasoning, the more likely that they are going to be to follow it. Mark stuff confidential. Anything that's got confidential information, it should have a great big sticker on it that says confidential. That's about it for that. So I'm going to go on to copyright. Again, we talked about that. The minute you fix it in a tangible medium, you have copyright in it. Do you need to register it? No. You can, but you don't have to. Why would you register it? You would register it if you thought that at some point someone was going to infringe it and it would be worth hundreds of thousands of dollars. And that would be one reason to register it, just because it gives you a little oomph. Even more importantly, what if it's something you think is going to be infringed, but even if it is infringed, it's only going to be worth about $10,000 a year. If that's the case, you can't really take it to court because it's going to cost you a lot more than that. If you register it, you can get statutory damages, and those can be up to $150,000, even if it's a cartoon. So that's one thing to keep in mind. Information that is copyright protectable, fixed in a tangible medium, you might want to register a copyright for those reasons. So how do you indicate to someone that you believe you have copyright in it if you don't register it? The same way you indicate to someone that you have a registered copyright. C in a circle, year, name of the owner. Put it on everything. If you don't walk out of here with anything else today, write that down and make sure that when you go back to your own offices, you think about how to implement that. It's simple, it's free, and it works.
Can you copyright the contents of a spreadsheet?
Sorry?
Can you copyright the contents of a spreadsheet?
No, and you probably can't even copyright the arrangement of your spreadsheet unless there's enough creativity involved in how you've arranged it, and that would be a really tricky one. Same way you can't copyright a recipe, but you can copyright a collection of recipes in the way you've ordered them and the cute little, pictures you put beside them. You can't copyright a form. We have a number of clients that have these different forms that their own customers are using or they want their customers to use. Ooh, I don't want my competitor to use that. I can copyright this, right? No, because it's not considered creative. It's an arrangement of information that anyone in that business would need to collect. So very, very rarely could you copyright a form. But if you put C in a circle on the bottom of it, no one's going to come after you, so try it.
Actually, could you hit that last bullet point real quick?
Yep. Okay, so term of protection is really a long time, so it's typically 75 years plus the life of the author. So if I die next year, 75 years after that, if it's my personal copyright, it'll die.
So what about if that, for example, if a business had a copyrighted of an image that you liked and that business no longer exists, how do you, that, I assume that they still have that copyright, that business
That's a
now.
really good question. I don't know if I know the answer to that. So I don't know if you're hearing this question was, you maybe were the employee there and you created this really great thing and your employer rightly claimed ownership to it. Now this employer is out of business, defunct. What happens to that copyright? Well, it was an asset of the company. So whatever happened to those assets, typically that's where it would go. So if the assets were signed over to a bank, the bank probably has it, even if it wasn't, registered with a piece of paper. If those assets went with one of the employees or another, and went somewhere else, then that's probably where it went. Because it typically would get assigned in a big kind of a massive assignment of assets. If it's not useful to anybody else and you can track down where it went, I'd be really surprised if you couldn't get an assignment back. And then there's the practical question. The company's dead. Nobody else cares about that anymore but you. And so who's really going to come after you for infringement? So there's that question too. Now practicalities, if you get too crazy about the legalities of things, you're going to drive yourself crazy. You have to also try to put some practical knowledge involved with it too, and try to go with it. Okay. And I touched on this before. Again, if you want to file and register a copyright, the reason you would do so is so that you could qualify yourself for statutory damages. Otherwise, an unregistered copyright, you can still bring a copyright infringement suit. At that point, you have to apply for registration. That's the requirement to have standing to sue. You just won't get the statutory damages. So then you say, why would I sue if I'm not going to get a bunch of money? And unless it's a highly valuable copyright, that's typically true. I worked with a number of t-shirt designers. In Des Moines, there's a lot of them. And there's a lot of copyright infringement going on. And typically a good solid cease and desist letter followed up by a phone call from their lawyer works pretty well. So there are ways to make it work.
Is the Copyright Office, is that only federal or is it state and federal?
Federal only. There is not a state. Yes, sir.
In the case of t-shirt designs, is it the actual designs or the words or?
Good questions. So the question is, I think one question is going to be, can I copyright a slogan or a title? And the answer to that is no, which is really weird because there is creativity in a title. There is creativity in a slogan, but they drew the line in the law and said a slogan or a title is not copyrightable. The contents in the book that is under that title, yes. The title itself, no. Strange. A t-shirt, slogan, no. And my kid has the cutest t-shirts now, and well, they were cuter when he was little, but now he's older and they're all these wrestling t-shirts and they're not so cute anymore. But they all have slogans and they've all got these little wrestling figures. Well, the wrestling figures are copyright protectable, but the slogans are not. Can you answer that?
So if I was to make Helvetica-based t-shirts, I could put whatever I wanted on it.
You could put whatever you wanted on to it unless it was a quote from someone else, unless it was a paragraph that is recognizable, and you're going to get yourself in some trouble. One thing you should know, work made for hire doctrine. If it's something that an employee prepares while employed by you and it's within his scope of employment, then that's a work made for hire, and that is yours. A contractor, though, is not an employee. So when you have somebody who's going to create that software for you, you definitely need to have an agreement that says that that software is yours. All the code, all the screenshots, everything. I can't tell you how many times we run into, I had somebody do a website design for me, and it's mine. No, it's not. Not unless you've got something specifically saying that it is. So be really careful of those. And copyrights are weird. They can be jointly held, and these are not quite as problematic. So you and I write a song together, and then I go make $1 million with it, and that's okay with you because I owe you for my sales. Patents, remember, was not that way. It was exactly the opposite. I make $1 million with my patent that we jointly own, and I go, nah, you don't get any. But with copyrights, I owe you. Strange. Again, all this can be taken care of with really good agreements. The idea here, for me, is to let you know where those pitfalls are, so that at some point, when you're working with somebody or working on a project, the antenna kind of goes up and you go, oh, wait a minute, I think I'm supposed to have an agreement for this. And I have 5 minutes left, and I'm going to cover trademarks because we need to, and then I probably won't get any further than that. And I had some really great ideas to talk to you about. Trademark can be anything that identifies a good or a service. It can be a color. Remember NBC had that the peacock, and when its tail would light up one feather at a time, it had the tone, it went doo-doo-doo, or whatever it was. That is a trademark because you recognize it. The peacock was a trademark because you recognize it. The pink on the outside of insulation when they're building a building, Tyvek, that's a trademark, registered. So it's a trade dress, but it is registered and protected just like a trademark. So there's all kinds of ways that you can create a trademark. The Nike swoosh Everybody recognizes that. Common law protection begins the very moment you start using that trademark in commerce. Now, if you're just using it while you're developing a product and it's not a product that you can actually offer for sale, you don't have trademark rights at that point. But you do have those rights the minute you start using that in commerce. And those rights build and build in strength as you use and use and use it, and it becomes more and more recognizable. The other way to do it, as I mentioned to you earlier, is you can register it, and then it has some automatic nationwide rights, which is a pretty nice deal. It's not very expensive, and it's a pretty easy thing to manage. You can keep the same trademark. You can keep the same trademark for as long as you like to, as long as you are continuing to use it in commerce. When you stop using it, it stops. It ceases being a trademark. Question.
And is that, when you say go ahead and trademark it, do you mean TM or do you mean Circle R?
Good question. So the Circle R indicates that you have actually registered it
Okay.
with the federal government. A TM can mean that you just are using it as a trademark, as a common law trademark, or it can also mean that you have registered it with the state. So if you register a trademark with Iowa, you use the TM. If it's a service mark, it's indicating that you're offering a certain service, that's an SM, or it's an R in the circle, depending if it's registered or not.
Okay.
State registration's about, I think it's like $50. It is very inexpensive. And I would never say don't do it, and oh no, just do the federal, because there are lots of restaurants are a great example. One or two restaurants maybe that you own here in Des Moines and you don't plan to expand it, or you don't think so now. $50 is a very inexpensive way to get some trademark rights.
Right.
And it provides notice to everybody in the state that you've got this mark.
Okay.
And when I do a trademark search to see if there's clearance for a particular mark a client of mine might want, my trademark search includes looking at state registrations all over. And so if that way, I would catch that and I would say, oh, client, you can't do that because there's this trademark in Iowa, and there's a likelihood that, or in Nebraska, that trademark might get used in Nebraska. You might not want to do that. You can without infringing it right now, but you don't know what might happen in the future. So it really does kind of provide a little bit of protection, even if it's for $50, it's very inexpensive to do that.
And who is the registering agency for that? Is it the state?
You can get on the, why am I blanking on this? The state attorney, right?
Secretary of State.
Yep, Secretary of State, their website shows you where to get the paperwork. A lot of times you have to call because it's not very automated for Iowa yet. Some of our other states are more automated, but Iowa is not. So you can call and they'll send you the filling out forms. You can fill them out and send them back in. It's not very expensive, pretty simple. There was another question.
What trumps in trademarks? Federal registration, state registration, or somebody that was using it in commerce?
Date of first use will trump. Now, the question becomes whether you had constructive notice through federal trademark registration, or whether there was no registration, so therefore you had to have had actual notice. And that becomes a little bit dicier. But the short answer is first date of use is the trademark owner, as long as you continually used it. If you take a break in the middle and don't use it for a couple of years and you come back and use it again, now you've got all kinds of problems. Yes?
First use, how do you define first use?
First use where you have it either on a product or you are using it to describe a service that you are actually offering. So not when you're going to pitch to find funds, it's when you are actually ready to offer that product or offer that service. Yes?
This isn't on the word or the name itself, but the stylized, the logo of the thing, right?
No, trademark can be on just the name. There are several ways to do it. You can file it as what they call a standard character mark, and that's just for the letters. And then you can do anything you want to with them, and that's a pretty good deal because you get more bang for your buck that way. So now you can use it in different fonts, you can stylize it, you can create design around it, whatever you want to. So a standard character mark is the best buy. On the other hand, if you've got a really cool logo and you love it, and you really don't want anybody else to use it, you better register it because those are pretty thin, that's pretty thin protection. So if you have a registration, you're going to get a better result if you ever have to tell someone they need to stop. Yes.
So in regard to like my product, I have a social network I'm creating, and I have a symbol for it, but the social network is yet to be created. But we're excited about it. We've had some T-shirts made, and we got the symbol on the T-shirts, and we've sold T-shirts. Is that automatically under the,
Can you tell me a little bit about your symbol?
how it looks or what? It's a triangle. It's got a letter inside of a triangle.
Okay. The reason I ask is because sometimes with the logo, you have dual protection. One is copyright, because it's creative. And that one might be thin, but you go there, you have some copyright protection in it. And then the minute you start using it, you have trademark protection.
Okay. So even though the social network's not up yet, but we've got it on T-shirts, and some people bought the T-shirts.
So you may have, yeah, like I said, so for that reason, you probably have some copyright protection. I wouldn't want to hang my hat on that very long.
Yeah.
Okay. Did you? No, it's not in the name. Okay. You need to be really careful when you select your mark. Before you fall totally in love with your mark, you need to take a look and see what else is out there. The U.S. Patent and Trademark Office has a database of registered and applied for trademarks. So there's no reason not to take a look. The state does not. It is, you can't find out what others are really registered. It's difficult to do that. I shouldn't say you can't, but it is difficult. It's not online. So the state registration is not as easy, but it is well worth your time to look and make sure that there's not somebody else using a trademark that is yours with a similar good or service. Now, if you're selling computers and somebody's got the same trademark for shoes, unless it's a really famous trademark, you don't have to worry about that. It's just whether it's a similar mark and a similar good. So save yourself some headache and some heartache and try to do a little bit of looking around first. And we talked about several times whether to register or not during our conversation, so I probably don't need to spend any more time on that. But one other thing you do need to know about trademarks, and that is if a competitor down the street starts using a mark very much like yours, and that competitor is equal or maybe stronger than you are, and you go, I just don't want to have that, I just don't want to have this fight, I'm just going to ignore it. You can do that, but you will lose your trademark rights in your trademark. So anytime that you know or see a potential infringer, you need to send them a cease and desist letter. Or you need to understand that your marks could be gone as soon as they get famous and you are not. Yes?
How often in type or collateral do you need to put that trademark on the name when you're using it?
You have to have it the first time it appears.
And then after that?
Right.
Okay.
So if you've got a website and you have it on the top, you know, with its logo and everything else, it goes on there, good enough.
Okay.
I'm going to stop just because I don't want to take more time than allotted. But I do want to tell you thank you for the questions that you had. And if you have some other ones, we can wrap them up. I'll be around afterwards if you want to ask questions that way.